As chair of the commission, I call this closed session of the Michigan Independent Citizens Redistricting Commission to order at 4:05 p.m. For the public record, could the secretary please take the roll? Could the secretary please take the roll?
Commissioners, please say present when I call your name. If you're attending today's meeting remotely, please disclose during roll call that you are attending remotely. You know the drill. Doug Clark.
Present.
Juanita Curry.
Present and attending remotely from Detroit, Michigan.
Anthony Eid.
Present.
Brittany Kellum.
Present.
Rhonda Lang.
Present, attending remotely from
Steve Lett. Cynthia Orton.
Present.
MC Rothhorn.
Present.
Rebecca Zatella.
Present.
Janice Follett.
Present.
Aaron Wagner. Aaron, I'm going to prompt you to unmute on your phone.
Present, attending remotely from Charlotte, Michigan.
Richard Weiss.
Present.
Dustin Witches.
Present.
All commissioners are present.
Thank you, Ms. Reinhardt. Okay, we have entered a closed session to discuss the attorney-client memos that we received from our general counsel and Mr. Adelson. Mr. Adelson or general counsel, who wants to lead the discussion?
So I will start. Thank you, Madam Chair. So I will start that again, stating for the record and the closed session minutes that the closed session is called in accordance with Section 8H of the Open Meetings Act, being MCL 15.268H. The session was called to occur on Wednesday, October 27th, upon adoption of the resolution, and the closed session was called to order at 4:05 p.m. to discuss the privileged and confidential memos being Voting Rights Act of October 14th, 2021, and the history of discrimination in the state of Michigan and its influence on voting of October 26, 21. These memos are both attorney-client privileged communications that provide legal advice to the client, prepared by counsel in regard to the Voting Rights Act, and are therefore exempt from disclosure under Section 13G of the Michigan Freedom of Information Act, being MCL 15.243, subpart 1, subsection G. The rules for closed sessions are that the confidentiality of the closed session, none of the discussion topics or documents may be shared outside of this room. Everyone received the confidentiality agreement that if you have not returned to either Sue Ann or myself, please do so. The rules additionally that the topic of the closed session can only be the Voting Rights Act based on the two memoranda that are the basis for this closed session. If the topic veers off of this course, I will provide a warning. If the conversation does not cease immediately, the closed session will be halted and we will return to open session at that time. If you have any questions about either of these two things, I know this is our first closed session. So again, we're here to talk about the VRA. We're here to have an open conversation between the MICRC and its attorneys about the VRA. And with all that being said, I'll turn it over to Bruce.
Thank you. And thank you for the opportunity to have this meeting. Julianne and I thought that it was important with the, as a result of the memos, the information that's being discussed in the conventional media, on social media and everywhere, to answer questions, provide some advice about a path forward, and discuss what the Voting Rights Act actually requires. And let's start with that. The Voting Rights Act, as you know from our discussions previously in the memo, does not require any numerical amount of majority minority districts, indeed does not even require majority minority districts at all. The Voting Rights Act, as you know, is designed and intended to provide an opportunity or ability to elect on the part of protected categories under the statute. That's based on race, color, and membership in a language minority group. There are no guarantees of success. There is nothing in the VRA nor in the jurisprudence that requires the success of any particular candidate or that any particular candidate of choice be of a particular race. Typically, as has been seen in court decisions going back decades, a candidate of choice of a minority group is often a person of a minority, but that is neither required nor does it happen in every circumstance. All of that ties into what we've been stressing for a while. This is a data, law, analysis, election results driven process. We have become concerned that there is so much misinformation out there. We wanted to have an opportunity to set the record straight in a sense, provide our advice, provide you with information about what the law actually says, and to encourage that as we move forward over the next 8 days, if there are ongoing questions or uncertainties, please come to us, as many of you have, to ask questions, to get some additional information. But we thought it was really important to stress these threshold items. And as you know, too, where we are today. As you recall, on September 2nd, Dr. Handley presented her racial block voting analysis. Racial block voting analysis is required by the Supreme Court pursuant to the Voting Rights Act. In order to determine if there is racial block or racially polarized voting, if there is, what is the remedy for that? The remedy is also informed by Dr. Handley's conclusion of the VAP, the voting age population that's required, or that she has concluded minorities need to elect a candidate of choice. That's key, because rather than just assigning numerical numbers and talking about a district, I read the other day that someone suggested, well, why don't they just create districts that are 55 to 58% Black? Well, what's the basis for that? The Dr. Handley's analysis does not include that. And we've never recommended that a arbitrary percentage of minority voters is needed to comply with the Voting Rights Act. In addition, one of the differences this cycle, redistricting cycle, compared to 10 years ago, and something that Julianne and I talked about a while ago, and we've been actively thinking about as the process has unfolded. The federal judiciary is more conservative than it was 10 years ago. The judiciary, particularly the Supreme Court, on several occasions has indicated some reluctance to abide what they consider to be race-based solutions, race-based answers, race-based compliance. So that is yet another reason why just having arbitrary numbers, 60%, 58, whatever they are, under the premise of the VRA, I think is particularly fraught this cycle. It's something that we have actively thought about, been concerned about, and that's yet another reason why we stick to the data, the analysis, the election results. I also wanted to comment briefly on the Voting Rights Act and primary elections. We've heard a lot about that. Yes. Election results. Well, the data is like what's in the active matrix. The data includes, yes, Dr. Handley's analysis. Yes.
Sorry about that. I forgot. So yeah, the data is in the active matrix. The analysis is Dr. Hanley's analysis primarily, and the election results is also in the active matrix, but it's the election results. So those, okay, thank you. Just wanted to be clear.
Sure. And to your point, as you know, the matrix includes one primary result statewide from 2018. The reality in Michigan is there are no more statewide primary results. So I know there's been a lot of talk about primary results. What's also important to remember, and I don't know that we've touched on this specifically, often in primaries, there may be a multi-candidate field that, let's say, has 7 minority candidates and 1 white candidate. I'm just saying that at random. Remember, one of the keys for Voting Rights Act is, and the Thornburg versus Jingles Supreme Court case, cohesiveness, meaning that minorities have to vote essentially for the same candidate. If you have 7, 6, 5, if you have multiple candidates, minority candidates in a primary field, it would be very difficult, in my experience, for one to achieve 50% or more so that that person could be analyzed to be the candidate of choice. That's one of the challenges with primary elections, so that although primary elections, I agree, when they're available, can be helpful, it's also important to realize in a multi-candidate field, the Voting Rights Act doesn't pick favorites in a sense. It's all about the voters. It's not about the candidates. So if the voters are showing that they are preferring multiple candidates, then the rhetorical question is, well, who's the minority candidate of choice? It would be, in my experience, very difficult in a multi-candidate field to come to that conclusion. So that while primaries can provide useful information, please be advised that they don't necessarily they're not necessarily dispositive. They don't necessarily tell the whole choice. Remember, the Voting Rights Act does not require a guarantee that any particular person will be elected. It's opportunity to be elected and ability to elect. That's what Dr. Hanley's analysis is premised on. Her analysis of a percentage that's needed, threshold percentage for minority voters to achieve that opportunity or ability to elect. So these have been among the larger concerns that we've had with either misinformation or no information. And along the same line, I have to point out that of all the studies, well, I shouldn't use that word, of all the information that's been put out there, there are no racial bloc voting analyses that we've seen that contradict or even address or even exist to counter what Dr. Hanley did. The information for example, in the AFL-CIO, the Fair Maps report, they mention that the Voting Rights Act requires, if you have a certain number of majority minority districts, you must have the same number. That is legally and factually incorrect. That's part of what we've been concerned about. These documents are infused with either misinformation or lack of information. The Michigan Civil Rights Commission document, one of the concerns that we have about that is it presupposes if a minority candidate, a Black candidate, wins in a particularly packed district, like a 90% district, I think was one of the ones that was referenced. The report makes the assumption that there are Hispanic and Asian voters in these districts, and ipso facto, they supported the Black candidates. That's just beyond the pale of being insupportable and incorrect. Drawing that conclusion is based on no analysis and is just woefully misleading. So the information that's out there does not contradict what you have been doing, what you have relied upon, what the law talks about, and sometimes goes the other way and provides incorrect information that's misleading or can engender opposition to something that is baseless. It has no legal support. So we've talked about this for a while, and it just came to the point recently that we both concluded that we really need to just lay this out, make it really clear that these things are just not true. To that point, in one point about going forward, we have some thoughts about, with some suggestions about how to deal with some of the issues that have come up recently. But one of the things we have to stress, emphasize, insist on, plead, beg, and say, please. Please don't use phrases about adding Black people, subtracting Black people, adding white people, subtracting white people. We're going in a little bit of a different direction. The reason that one of the reasons we wanted to have this session is that in looking to the future, looking over the next 8 days, we don't want to give people out there specific paths to challenge what you're doing. Remember, one of the things we talked about initially is legally race cannot predominate redistricting. It can be one factor of many. But when phrases like that are used, it just ostensibly rockets up to the top, gives people the ammunition that they're looking for. And to that end, there's a substantial record, obviously, the commission has put together. But since you're in the last phase now, people are going to focus, I'll borrow a phrase from some, I don't even know who said this, focus like a laser beam on what happens now. From now until next Friday. So that even if comments were made previously, the focus will be on what you do, what the dialogue, the conversation is now, much more than what happened before. That was true in Arizona. The lawsuits were based on the changes that were made after the draft maps were approved, after the public hearings, when we went into the final mapping stage. The lawsuits focused there. What happened before was preliminary. And I think that that's also part of what we wanted to stress. These draft maps are preliminary, as you know. They're trial balloons, they're not final. You can make decisions about how to deal with these maps up until your deadline. So I think that there were a lot of useful comments. I want to highlight one particular area of comments. A lot of information, as you know, that has been brought out that can be evaluated for what decisions you want to make going forward. One of the comments that I want to focus on, or an area of comments, were some comments in Flint yesterday, and that the focus of most of the comments about keeping Flint whole or Flint together, if you listen to them, were not racial. They were about, we want to elect someone who lives in Flint. Having lived in Flint and having voted in Flint, I understand the difference between City of Flint and Genesee County. Very different, demographics very different. So that description was not race-based. It was essentially keep our community together, keep our folks together, keep our neighborhoods together, because we know what's best for us with all of the tragedies that Flint has experienced. And I think that's one of ours, as we've talked about, one of our suggestions for a path forward, that rather than focus on race predominantly, which of course, as you know, we strongly advise not to do, take a lesson from Flint in a sense. The focus being, keep us together. We want to elect one of our own, not of any particular race, but out of concern that our needs as a community will be best served by electing someone who lives in our community. So that's one of our takeaways from yesterday. It's something we've talked about, and I think that that can be a path forward in addressing, evaluating, debating, and discussing some of the comments that you've heard over the last week or so. Yes.
Commissioner Eid.
So how do we do that without packing the districts?
Can I?
Commissioner Kellen.
I think what I hear Bruce saying is the rhetoric and language that we use to justify. So like, what we're actually doing when we're reunifying folks is, of course, we're putting certain races together. We know that. But then what we say is that we're observing the fact that these areas are uniquely different, like when we think about Detroit. And so we're not using the language that is going to question the maps when it gets to that point. So I think if we go back and look at the cultural aspects in the neighborhoods, whether it's Flint, Saginaw, you know, the places that are legally Black, just saying it like that, will be there. The undertones will be accomplishing what folks want, but doing it in a way that still upholds our criterion and everything else, like our matrix and our data and all that other stuff. But that's how I understood him to say it, and what I've been thinking about. But I don't know if that's what you were asking necessarily.
Commissioner Orton.
Before we move on, I want to address Commissioner Kellum and Commissioner Reed. One of the things that has been missing in the public comments is the public has been like quite insistent that these are Voting Rights Act violations. Let's take a step back. They're not Voting Rights Act violations. Why? Dr. Handley has determined through her analysis the VAP that's needed to elect in these areas. And I take your point, I agree that packing districts the way they are now would be problematic. And we're not talking about that because we're really not talking about, the Voting Rights Act. In my discussion about Flint, you notice I didn't say the Voting Rights Act at all. I didn't mention race at all. The reality is that there are, not only in Flint, but there are, I'm confident in looking at some of the comments, communities that were split, neighborhoods that were split, historic neighborhoods, particularly in the Black community, that have that same commonality as the comments from Flint. We want to keep our community whole. This is not about complying with the Voting Rights Act, because it's been our determination based on the analysis that you've met those thresholds. And there may be one or two, I think, that we can evaluate, but this is more a keeping neighborhoods whole, keeping communities whole, listening to the public. That's not a Voting Rights Act issue per se. Yes, if you had a downtown Detroit district where the Black VAP was 20%, yes, I think that would definitely be something that we would need to address, but that's not where we are. So that's a very important divide, and something that I know Julianne and I felt and do feel very strongly about, that these comments about violating the Voting Rights Act and Section 2 and talking about various Supreme Court cases. Well, no, because remember what's out there. No one has said that these thresholds are incorrect. They may like, certain thresholds to be different or higher, and they may question the why they're being used. But no one has said, well, our analysis shows that the VAP should be 48.9%. Nobody said that. And I think that that's among the many telling omissions out there. So this is a less of VRA issue, that's one of the reasons in putting out the memorandum to distinguish what does the Voting Rights Act require, not majority minority districts, not numerical percentages, ability and opportunity to elect, period. The Flint issue is communities, neighborhoods, and our being able to elect someone not based on VRA requirements, but who understands what it's like to live in the city of Flint compared to somebody who lives out in Genesee County.
So I would add to that, one of the things I thought was most revealing for me was, you hear all these statements that people have said, and it worries me deeply. And so I looked at the Promote the Vote maps, and more specifically, I looked at their statistics. And if you look at our maps, like our congressional districts, we have 2 that are within the range of what we were aiming for. So they're in the 40 percentile of BVAP. If you look at the Promote the Vote maps for their congressional, they have one district that's 43% and one that's 50. And then if you go to their Senate map, it's the same thing. If you actually look at their Senate map and look at the statistics and compare it to ours, I'm looking at their Senate map right now, 40%, 42%, 43%, 47%, 41%. So their numbers aren't any different than ours at all. And so it's like, how is your 40% different from our 40%? And my takeaway is that it isn't about the Voting Rights Act, and that their maps are the same as ours when it comes to the percentages. So it's more about the feel.
Yes, that's a great point. Madam Chair, because Julianne, we were just wondering, did they use like our RBV analysis? You got to kind of wonder about that
Yeah.
because they obviously don't have their own. And that being said, keep in mind that the VAP numbers, of course, these are estimates. They're not written in stone. There are, I think, neighborhood community of interest issues in the Black community in Detroit that can be addressed, just like comments that you heard about Hamtramck, for example. But we view these more as neighborhood community concerns, because unlike the naysayers who are out there, they haven't come to the table with any analysis to back up what they're talking about. Even one reporter asked me, is there a magic number in the Voting Rights Act? Does it say a magic number that we have to have X number of majority minority districts? And the reporter was shocked when I said that, no, it's not about magic or numbers. It's about what is the analysis show. Now, Dr. Handley, as you know, is doing additional analysis, and we're going to be speaking with her, get more of a feel of when that will be done. But unlike all the organizations and the people who are speaking very loudly, what we're doing, what you're doing, is you're basing your work on analysis. So that one important distinction, whether it's Flint or however many districts in Detroit you decide to adjust that way, because we're not saying that you need 50.1% to elect. And I want to make sure that we're clear on this, that's not packing. Let me say that again. In Flint, we'll use Flint. Let's say Flint is kept reasonably whole. Let's say it's 54%. That's not packing, because we're not creating a district with a certain arbitrary percentage to stuff Black people into this area more than they need to elect. What you're doing is something that's not Voting Rights Act. Yes, and that community, that neighborhood sense, that's a very important consideration. And that what's also important too, with all of the comments in the last couple of weeks, the comments that have recommended a specific numerical number for districts, the vast majority of comments that I heard, it was 50.1%, not 59. Or what does that tell you? That's less a VRA issue and more of a, well, that and a community-based neighborhood type vibe that's not saying we have to have this. It's something different.
It's based solely on race, those comments and a lot of that advocacy efforts. And I know Cynthia's arm is going to fall off if it's up in the air anymore. But one thing I wanted to highlight too about Flint, and I stepped out of the room a couple times for meetings, but what I wanted to highlight is what I was hearing was water crisis, disinvestment, GM leaving, the school board issues. There were a few commenters that talked about race or talked about the 50% plus one, or you have to pack us in because the primaries too many people run, although I think that was a predominantly Detroit comment. But so again, what I was hearing wasn't VRA advocacy. What I was hearing was community of interest advocacy, founded on their lived experiences and their history. And that's very different than doing that and running a BVAP number and using that in the analysis. That's not what they were suggesting, the majority of commenters. but I thought that was a fascinating thing as well. Did you talk about cohesion yet or not yet? Or we go to Cynthia first?
Yes.
Yeah.
Let's let Commissioner Orton go, or before she's worried she's gonna forget her thoughts.
So I did forget the first one, but the next one is, I was gonna say, when we're talking about this, if we choose to put anything together that we currently have separated, we go back to communities of interest. It's a community of interest thing, not a VRA thing.
Just like when you were mapping, when you were mapping, you were
Right.
talking about the public comments, you were talking about the people that were giving testimony in the neighborhoods. You had other sources of data that you were looking at. You had the active matrix. You had all of these sorts of things that inform your work and resulted in draft proposed maps. I think it's critical. Again, they were draft proposed maps. I don't think anyone intended for a draft proposed map to make it through to the final maps without any at least discussion. I won't say modification, but at least a discussion about should anything be changed? What did we hear at the public hearings? How do we move forward on this map?
Well, I do also want to say, I hope we all recognize, at least I think, many of the comments that we heard, while they were saying that it was a VRA issue, it's a partisan issue. They have an agenda, and we need to be able to spot that and weed that out and not fall for that.
Yeah, and I think to that point, I think that's a really excellent way to look at it. And I also have to say that the comments like that are in no way unique to this commission or Michigan. That there have and continue to be many situations around the country where minority voters are packed into a district as a result of a working arrangement between the two major political parties. That's been true for a long time, and I've seen that for a long time. And that has often resulted in packed districts. And to your point, Commissioner, I think that being able to separate that out and realize where these organized interests are coming from, I think that's very important. I want to make one quick comment. I know Commissioner Curry has her
Yeah,
hand up.
Commissioner Curry has it.
One of under the Thornburg versus Jingles Supreme Court decision, in order to make a case for a Section 2 vote dilution requirement, you have to show that minority voters vote together, that they support the same candidate, that there's cohesion. In these multi-candidate fields, there really isn't cohesion because there's support for various candidates. What's also interesting, in the 2018 primary election, remember El Sayed, Tanadar, and what I spoke to Dr. Handley about that to see if that might shed some light on Black voter behavior. She said, what it does, it shows that there's no cohesion, that Black voters supported in varying degrees all three candidates. So that means that election is a valuable one. It has been very useful in helping us kind of figure out Arab American preferences. But the only thing it tells us about Black voter preferences is there's no cohesion, that they support each candidate in varying numbers, not necessarily reaching a majority. So that's really important too, that with these multi-candidate fields like this 2018 primary, if the largest minority group is not supporting the same candidate, they're not voting together cohesively, that's one of the factors for Jingles. If you can't show that, then you cannot prove Section 2 discrimination.
Commissioner Curry?
Yes, I want to comment that I'm tired of looking at this screen. Is there any way possible I can feel more like I'm there with you guys if I could see more faces? Because all I'm looking at is a screen.
Oh.
Hi, Juanita.
whether.
I mean, it's strange being out here trying to keep my concentration, just looking at Michigan Independent Citizens Redistricting Commission screen.
Commissioner Let, or Sarah, is there a way that she can fix that? Can she?
I
Yeah,
mean, we
think you can-
usually do it when we're in sessions, when I was there. I can get
you
it.
just want- Yeah, you should be able to go to the upper right corner and change, it should give you a drop down up at that, there's like a little toggle and it'll say like change view and you can do like gallery, side by side. I'm trying to do this from memory. Yeah. Speaker. Yeah, you want to do gallery probably or speaker.
To see everybody.
Can you see that little in the upper right?
I've got the upper, yeah, but it's still not giving me anything. In fact, now
should
it's all
either-
gone.
Oh, you should have the option for like speaker, side by side, gallery, and you probably want like gallery. or
Okay, it's
speaker.
just been removed, so I'm going to leave it alone.
Okay. Sorry.
I'm
Juanita.
going, good night.
Good night. Don't go yet.
Can't
Commissioner
see
Lett,
anything, so why
Yeah.
stay?
Because
you can hear us. You can
because
hear us.
Commissioner
No,
Curry,
no,
you need to-
no, you all need to fix this thing right. I want to hear and see so I can have some kind of
Juanita,
correlation.
unfortunately, we can't fix it for you. You're gonna have to change your settings on your computer.
I
And there
just
should be
did.
a option on there to change it to gallery view, and then you'll be able to see everyone.
I had gallery and it only showed myself bigger. Okay, I'm not seeing any faces. That's okay. You all not getting what I'm trying to say.
No, we know what you're saying. I just don't know how to fix it for you.
I think you would have to do it there. I can't do it. I see it's changed somewhat, but Mike Brady is not showing, Rhonda Lane is not showing, Aaron Wagner is not showing. Then I still have a commission with a screen. That's better.
That's better.
Thank you. Somebody know how to do something.
All right. All right, Commissioner Clark and then Commissioner Lett, sorry.
Okay, Bruce, I agree with everything you said about Flint. As I reflected back on that when I was driving home last night, I agree. But Detroit's different. And so your comments were, it appears to be a neighborhood issue and they want to have the neighborhoods consolidated. So we can do that and make minor modifications to the districts we've done. But that, to me, doesn't fix the problem that they were complaining about. The problem they were complaining about was, in my mind, was that the districts didn't give them the opportunity to elect. And so changing just the neighborhoods is not going to change that problem. So the way to change that would be to make the districts compress them so that more of the blacks are in Detroit. But then you end up with the comment that Anthony was talking about. Are we packing? So how do we resolve something like that?
Commissioner, once you answer, then Commissioner Lett and then Commissioner Edison.
Well, I think that's a great question. And I think that and you're right that a lot of the comments were, we can't elect. Of course, we don't agree with that. And that you have analysis that supports our conclusion and our advice. They don't have that. So the level of VAP that is needed, I think Dr. Handley established that. Now, I think that what's also true, that whether it's the reunification of Hamtramck in one district, I can't tell offhand whether how that changes from a population standpoint. But in a sense, I agree with you that we're not talking about vast changes. We're not suggesting vast changes to these districts. That my recollection is that there are neighborhoods that were, whether they were, I don't want to say split between counties, but that were, excuse me, split, that just like the commission addressed the lakeside districts, and there've been a lot of comments about Ottawa County, Midland, and a lot of other issues too, that these are comments from the Black community in Detroit, that if you look at the historic nature of Detroit, which also the neighborhoods in Detroit. I think that our suggestion would be that that's something to evaluate and something to look at further. And remember too, that with the, the mantras in a way in evaluating this, the Voting Rights Act is about opportunity or ability to elect candidates of choice, not candidates of a certain race, and not guaranteeing that any one person or one race wins. So that the process now at the end is a challenging one in the sense that you're filtering a lot more information than you were 3 weeks ago. A lot of that information is at best misleading. And to Commissioner Orton's point, a lot of it has a specific agenda where the people behind these agendas want a specific, relatively high Black voting age population. We're not talking about that. And I think that let's also be, going back to what I had said before, that if you create districts or adjust districts so that they wind up having 50.1%, 51, 52% BVAP, we're not packing, because that issue is not addressing a Voting Rights Act issue that your lawyers are advising you about. Whether or not people in the community think it's a VRA issue is a different consideration. That looking at these communities, as the commission has been so responsive to, like with the Lakeside districts, I think that that's an important consideration. What's also important too, remember these last 8 days are people are going to look at this. This will be the focus of litigation, the focus of testimony, the focus of depositions. It's really important, your attorneys believe, that you show now an additional effort to address the recent concerns without packing, without making population choices at random, but that you show that we are addressing the concerns of the Black community in Detroit. We're addressing the concerns of the Black community in Flint. We're not doing it by creating 70% BVAP districts, but we are looking at these, we're taking them seriously, and you put on the record, show that you're doing that. Showing a court that this is what we did. That's what we did in Arizona. And there were a lot of concerns about, you made this decision and that decision. As you know, we backed up every decision we made. We explained everything. Being able to say, look at the changes that we made, look at the adjustments that were considered and approved that address these community-based neighborhood concerns. We think that's a very important place for the commission to be at this late stage, because that kind of offsets significantly whatever comments or whatever issues came up previously, because it shows, well, what did you do? What did you discuss? What decisions were made in the last 8 days? We see that as being a potentially tremendous benefit that takes away a potential avenue of litigation and gives you a substantial record to run on, in a sense, to show this is what we addressed. This is how we did it. And we didn't do it by packing people. We didn't do it by just randomly coming up with numbers. And we didn't do it because we thought that there was vote dilution and discrimination under the Voting Rights Act.
So with our spoke concept in Detroit,
Mhm.
do you think we're on the right track?
Well, I think that, and that's something that, I'm glad that you mentioned that, because that's something that we really wanted to stress, and that this is a good time to do that. Michigan, and this is part of the reason, well, let me back up for a minute. The memorandum on discrimination, history of discrimination, is important, because if this were a Section 2 case under the Voting Rights Act, the court would consider that. So we thought that it's important for the commission to know if there is any type of Voting Rights Act litigation. That's exactly what people are going to be looking at. That's what an expert will be hired to do. there will be a paper like that. So you're being able to see now what may happen in the future is important to know. And in referencing that, Michigan, as you know, has been a state since 1837. Legislative maps until now were drawn either by courts or by the legislature, whether it was in 1898 or 2000. So you talk about the spoke system. You spent a lot of time and hard work unpacking a city that frankly has been packed for decades, partly because of that arrangement we talked about between the political parties. That took a lot of work and we applaud that. We think it definitely is the right track. It expands minority vote opportunities. It expands opportunities for the Black community in Detroit to expand its influence. So yes, that is definitely the right way to go. We are not in any way suggesting, nor will we, that you pull back and go south of 8 Mile and stay there. We are not saying that at all. Your unpacking work was significant, never happened in the almost 200-year history of this state. And what you're doing, and I want to talk about this.
We have 3 people who have hands
Oh,
up.
I'm sorry.
Commissioner Lett, Commissioner Eid, and then Commissioner Lang. Commissioner Lett, go ahead.
Well, I agree with Bruce's analysis for the primary reason that I've been listening to what he's been saying, obviously, and I've been listening to what the civil rights director, who is an attorney, has to say. And so I was somewhat concerned as well if what he's saying is that if you have a majority minority district and you have to keep a majority minority district, then, and Bruce is saying, no, you don't, then who's right? And if it's Johnson is his name, isn't correct? Saying that you have to keep as many majority minority districts as you started with under section 2. I said, well, why not? I go look at section 2 and see what it has to say. So I've done that on a couple of times, and I did it once today as we're locked down, providing ourselves with security. Ha ha ha. There is nothing. I'll repeat that. There is nothing in the statute that talks about a percentage. There is nothing in the statute that talks about a majority minority district or a minority majority district. It's not even mentioned in the statute. So when he comes on in front of us and says that, as Julianne has stated, it's absolutely wrong. It's 2 paragraphs. I'd be happy to show it to you. Secondly, Virginia, great state of Virginia, tried this. They came out in a case, the recent case. It's give me the name. It's after Jingles. It's a very recent case. And it says, well, you have to have, they decided, well, we have to have a majority minority district because I think they were under VRA. And so they went 50 point something. And the Supreme Court says, no, you did that just because you were putting that 50+% race in to make that majority minority district. You only did it because of race. That is against the case law. And that is where the VRA in section 2 is analyzed, is in the case law, not in the statute. So the other thing is the case law and the statute and the case law interpretation is it's results oriented. It's not intent. So what that means is if we make a district and I'll pick 55% as the number, and we make a 55% district, that's pretty blatant on its face that the result that we've achieved is that it's a majority minority district. And it's presumed then that you did it because of race. And then the burden shifts back to you, us, to prove we didn't do that. Finally, in respect to Commissioner Eads, how are we supposed to protect ourselves? If you didn't read Edward's clip from 10/25/21, in which Mark Grebner was interviewed, you should. Number one, I like it because it's exactly what I believe. And he is the person I've known of him. He's not a personal friend, but he has been a political operative in Ingham County forever. And he runs a political consulting firm. And if you want to know who voted for whom, when, go ask him, he'll tell you. He says, communities of interest was created as a nebulous criteria that the redistricting commission could use later as cover for whatever map it draws. Communities of interest is a will-o'-the-wisp. It's a wreath of smoke. It can be whatever is necessary. The crucial thing is who decides what a community of interest is that gets preserved? The answer, the commission does. Who gets to review that? Frankly, nobody does. It's up to them. Was it originally intended? Yes, it was built in. It's nailing Jello to the wall.
I did see that.
Now, you can think that that's being rather over the top, but as a lot of people that have heard me talk, that's exactly what I believe. Who decides what a community of interest is? Doug asked that question right up front. First meeting, maybe second meeting. Who defines community of interest? And my statement was the community of interest defines though it's a community of interest. But that's what we can use now to justify what we're doing. And it's in the amendment. They put it in there for us. So let's use what we got. And I know that MC really likes communities of interest.
We know that.
He
yes.
really likes them.
He loves them.
So when we have a problem, MC, look at your notes and tell us what the community of interest is. But I mean, that's how we're going to do it.
Mhm.
Population, they got to be contiguous,
Right.
and then do what's best for the state. I agree with the people that out there said, do what's best for the state. And here's what we have to do in order to do that. And here's how we have to provide ourselves with cover.
Mhm.
We can do it tomorrow.
Tomorrow. So I have one follow-up question, and this is a yes or no question. Answer, please. Does the Michigan Department of Civil Rights typically enforce the Federal Voting Rights Act?
No.
No, okay. And that was my, no disrespect to Mr. Johnson, but I'm like, why is the Michigan Department of Civil Rights weighing in on the Voting Rights Act? That's not their jurisdiction. That's the Department of Justice. Okay. Commission. Political, yeah. It's advocacy. Commissioner Eid, and then Commissioner Lang, and then Commissioner Kelley.
Well, I agree with everything Steve just said. I mean, can't really argue with facts like that. I also reflected on the Detroit hearing, and being someone who lives there, who's lived in the city for 10 years, yeah, they were just wrong. Like, I hate to say it, but I mean, we have analysis, fact-based analysis that shows that, you know, their comments were not backed by anything other than their feelings, which are very warranted as they've had a long history of oppression. But as far as the maps that we drew, you know, I was very uncomfortable with them at first. I said it in a public hearing that, oh, you know, I don't know about this, but I went back to the analysis and tried to poke holes in the analysis. I really did, but I mean, I couldn't. It was a well done analysis. I wanted to ask our lawyers, do you think there's anything in that analysis that could be called into question?
You mean
'Cause-
Dr. Hanley's analysis?
Yeah.
I think we've always been consistent, even before the commission had Dr. Hanley and Mr. Adelson. The commission has consistently said that the data is going to drive the number of majority minority districts. Remember, we're getting a lot of pressure very early on. How many are there? Is there going to be 2? Is there going to be more? Is there going to be 1? Is there going to be 0? And the answer always was that that until the data is taken and analyzed, that is unknown. And so what the commission has is it has the data, it has the analysis, and it has the ability to make decisions based on that analysis. And I think the key, again, we've always been consistent, not only with the section 2 stuff, but with the case law. What does the case law say? The case law says the 50 plus 1% is garbage. The case law says retrogression is garbage. And you have advocacy people, and I respect their passion. I respect their lived experience, but what they're doing is advocating for the commission not to follow the law. And it's our job, as unpopular as it is, to try to keep you on track with the law and advise you as best we can. So no, I think you have exactly the data you need to make the decisions, the difficult decisions that the commission needs to make. And I think you have a wealth of other data to make other decisions on other criteria that we're not talking about in this session that can support those decisions as well. I think the commission should feel secure in its data and what it has available, and that you have resources to discuss those with from this point moving forward. But we've always been consistent, and we will always be consistent in that advice.
Commissioner Kellum? Oh, Commissioner Lang, I'm so sorry.
Pass.
Yes, okay, Commissioner Kellum.
Well, I just wanted to follow up briefly on what my colleague said. I agree. And I'm sorry, that's 2 words. I wanted to be as succinct as possible, as I know Commissioner Kellum has a comment, but I agree with what Julianne said.
I don't know if it's like a comment or, well, yeah, it is a comment. I'm getting a little uncomfortable because it sounds like we're being empowered to not change what we've done. I think we would be doing a disservice. I've lived in Detroit all my years, and I understand. I saw the politicians that got up and spoke, and I knew who they were, and I know why they were saying that. But the undertone that I know to be true is that in some areas, if we don't change, and if we are going to be acquiesce in our position that we've done such a great job, and the analysis says that, I think we're going to miss listening to the citizens in Detroit. And that really scares me, because I see a bunch of nodding heads. I see us almost taking on the position of what politicians have done and saying, oh, we did a good job and we're not going to change it. And there are certain people there. We all know that candidate of choice means electing candidates that look like them. Like, let's be clear. So on one hand, there are people there that want their friends to win, et cetera. But on the other hand, I can't ignore the people that are talking about how Southfield is ripped up, and that is true. How Palmer Park is ripped up, and that is true. And these are areas in which my mother and grandparents still live and that I frequent. So it's like, Anthony, I respect what you're saying, but the Detroit area is jacked up and we need to change it. And I don't want us to sit here and start thinking about ways that we can keep it the same.
And I want to jump in really quick, because we're not strategizing or planning or doing a course of action, because we're in closed session. So what we're doing is we're discussing information, and we're covering, again, the substance of Bruce's analysis. And what we're doing is we're distinguishing how what a lot of what you have heard is not supported by the VRA, is not supported by the VRA analysis, and whether it can be addressed in other ways is a topic for the open session and your deliberation and adjustment work. But again, it's that really the substance of a lot of what you were told about the VRA is flat out incorrect. It has always been incorrect. And that really was, particularly with some of the questions that we were getting, it was really important to have the VRA discussion collectively so that you'd benefit from hearing each other's questions and the fuller answers. But I just wanted to jump in on that again, because we are in closed session. So we're talking about the contents of the memo, what the VRA does say, what the VRA does not say, and how everybody keeps missing the case, not everybody in
Yeah.
this room, but however, like the public they're very passionate about what they want without accurately identifying what they want.
Correct. So what I'm saying is,
Yeah.
though they might be using the wrong terminology, I don't want us to ignore what they're actually saying. So if we know what they're saying, then we need to fix it. We need to, okay, yeah, you're using the wrong word, like you do it, a kid or something, but we know that we can go back and change it. So if that's if as long as we're all on the same page, that's all I'm saying.
And I think that to that point, I think that one of the most compelling reasons why we wanted to meet is to address what does the VRA require, what does it not require? And in moving forward over the next 8 days, that there are, particularly in looking at the potential for litigation in the future, that this is your time to create a vibrant, compelling record that addresses many issues. As Julianne said, we're not having a strategy conversation, but these are things that it's important to distinguish. This is the time to focus on creating that record, understanding what the VRA says and doesn't say,
I see you,
understanding
Commissioner Curry.
how all these interrelationships, how they come together. And also, as I said, that the point we also wanted to make about Flint, most of the comments didn't even address the VRA. They talked about the communities of interest and issues that are not VRA issues. That doesn't mean that they don't have their own compelling rationales, which is separate from where we are today. But that meeting spoke loudly about many issues. Most of them were not about the Voting Rights Act, and that's an important distinction, as well as creating that record going forward that will be examined closely in litigation. I want to mention there's one more point that we wanted to really stress, and this is.
Could we get Commissioner Curry first?
Oh,
Yeah. Commissioner Curry, go ahead.
Thank you. Sorry, Bruce, I lose my train of thought pretty fast, so let me get this in. I just wanted to say that when it comes to Detroit, the people that spoke out for Detroit, they use different terms. As somebody just said, they may say different things, but the issue is still as important as the water issue, all other issues that's around the state. Those issues are important because people died, people bled, people got hungry for it, people worked and strived just as hard as the people that had to change the way they drink water. And I'm all for people that had to, what happened in Flint, in Flint. But the same issue, different issues are just as important to people when they come out to tell you. Detroit just stuck to the, what is that, the VRA codes or whatever, but it's the same issue. And so we need to fix it up some, because just as we fix up one place, we've got to try and fix up everybody that has those deep concerns, because this is why we're hired. This is why we're here. And to run the thing about the VRAs, we got to stick to this or stick to that. I got you, Steve, you told her that was excellent the way you brought that out, and even Julianne, but we've got to look out for Detroit. I live in Detroit, so definitely I'm gonna speak up, but we've got to give the people some of what they want, because their issues is just as important as Flint's issue. And I love Flint too, I know a lot of people in Flint. I know the issues they had. The lady that did the commercials for the water thing, I kind of grew up with her. So I know the issues, but our issues here in Detroit, they come from the heart, they come from sweat, they come from work, hard work, and sometimes hungriness, sometimes people had
Okay,
to suffer for it. So let's deal with it too.
all right, so I'm gonna give you guys your first warning. Your first warning, we're Q&Aing on VRA, Q&Aing on the memos, Q&Aing on those types of
Closed
things.
section.
So, and I appreciate the fact, again, that how things grow out, and how the conversation grows out, that's a natural thing. So it's certainly expected, but we got to pull it. Are there any other specific questions on the VRA or the memos? If not, Bruce had one additional point. But again, we have to be focused on.
We are focused, Julianne. I'm focused.
No,
I know
I
exactly what-
no, I appreciate that, Commissioner Kern. I certainly apologize for interrupting you, but again, it's not we can't do the strategizing session, and I'm sure a lot of your colleagues have their thoughts as well.
I'm not talking about strategizing as much as being real. with it.
Thank you, Commissioner Curry.
You're
Commissioner Lett,
welcome.
and then Commissioner Orton, did you have a comment or you were just pointing? Okay, MC.
Oh, you just, two things to follow up with Commissioner Kellum. We can change. Nobody in this room is saying we can't go in and make changes. The only thing that we are saying is when we make those changes, we need to be cognizant of the VRA and how we're going to do that. And we're going to do it in, I'm assuming we're going to do it in Detroit, we're going to do it in Flint, we're going to do it in Grand Rapids, Ottawa, you name it. Second point, forget about litigation when we get into these maps. Don't sit there and think, well, I got to make this change, but am I going to get sued? You're going to get sued, so forget it. You're going to get sued, so forget that. Let's just do the best job we can with the advice that we're getting.
Okay, thank you.
And again, the purpose of the closed session was what is the VRA? What is not the VRA? And you guys were on the right track. You're staying on the right track. You have the advice, you have the data, you have all the tools you need, and you have the resources that you can tap into. Again, I would strongly advise you to listen to your lawyers, not other people's lawyers.
And I just want to say, remember the wording. This can all fall under communities of interest.
Right.
Absolutely.
MC.
So the two thoughts in my mind. One, we were in open session. We did talk about voting, voter turnout, and do we need data for voter turnout at all? And the second question was related to, should I not say anything about that?
Yeah, we can't. That's.
Okay, I'm not
you're
We're
getting-
going to address
you're
those in
getting-
open session.
I wasn't sure if it was related to VRA. The second question is also, is it related? We've asked for Lisa to give us additional analysis. Is it related to VRA? And is there any reason to think that we need to wait for that analysis or something like that? Do I even remember correctly?
Yeah. As you know, and as I mentioned earlier, Dr. Handley is doing additional analysis. We will get an update as quickly as possible. That's something that will be discussed in open session. It is a Voting Rights Act related, it's related analysis. And as she continues to perform her analysis, we'll have a greater understanding of where she is and when the analysis will be completed. That is a VRA analysis. I wanted to, in closing, I wanted to mention one issue that's connected with both memos, particularly, well, not particularly, it's connected to both memos. The Voting Rights Act, as I had said earlier, as you know, was passed in 1965 in response to the march on the march in Selma, the march to Montgomery, Alabama, the injuries that occurred that day, the violence. Was on national television, got a lot of attention, and really was seen as a galvanizing moment in American history. This law is about, as I said earlier, the opportunity and ability to elect, regardless of race, color, or membership in a language minority group. That's enshrined in the Voting Rights Act. It's also enshrined in the 14th Amendment to the US Constitution, which is related to the Voting Rights Act. And one The last point I wanted to make, it along with the opportunity and ability to elect. And when looking at the next 8 days and frankly, your legacy, at least certainly from my standpoint, you have the opportunity to create more opportunities than have been created in the 200 years in Michigan history. More opportunities to elect, abilities to elect. And again, no guarantees, no requirement that a certain person of a certain race must be guaranteed success. That's not what the Voting Rights Act says. But in thinking about the memos, as I was writing both of them, one of the issues that came up to me was legacy, because we really are at the legacy stage in a sense. That to me, being able to say and do that, to create the opportunities and abilities to elect that the Voting Rights Act was intended for, speaks to, is significant. And we don't always get to do that, but that's something that I wanted to convey. And that's based on my work enforcing the VRA for the United States and also the work that I've done since then. That's an incredibly powerful opportunity. That's what the Voting Rights Act says. That's our opinion. That's our advice, and that will be our advice going forward. Thank you.
Commissioner Ede and then Commissioner Orton.
Just one more quick thing, kind of a different topic. We also heard comments from Dearborn as it regards to VRA and Arab Americans. I think we've done a pretty good data-driven process looking at that, but do you guys have anything more for us in that regard?
Well, that's also a great point that I want to address. And I think, Commissioner, you had asked this a while ago, and I saw a couple of misstatements about this in the public sphere. The Voting Rights Act does protect Arab Americans. The Voting Rights Act protects people based on race, color, national origin. As you know, the United States sued the city of Hamtramck about 20 years ago for discrimination against Arab Americans. The United States and the consent decree signed by a federal judge stated that there were violations of the Voting Rights Act against Arab Americans based on race and color. So to be clear, the Voting Rights Act does apply to Arab Americans. They are a protected category under the statute. I did see a couple of comments over the last couple of days, and there was a couple from Flint actually, or maybe while we were in Flint, that said to the contrary. That is incorrect. The Arab Americans are protected under the Voting Rights Act.
Commissioner Orton.
So I just have a comment. I just want to remind us all that so we need to do this work. It was set up so that we hear from citizens, but I think at this point we need to kind of shut out all the criticisms that are coming and all the pressure, because these are all motivated, and we need to do our work using the VRA and communities of interest.
And I would just like to remind everybody that we are running out of daylight.
Yeah.
Go ahead,
What-
Commissioner Clark.
Yeah, and to add on to what Cynthia just mentioned,
Is it
Any-
directly related to the VRA?
no, anything discussed in this room today should stay in this room.
This is
period.
a confidential
Not
discussion.
discussed with anybody.
This is a confidential discussion. Again, as we started, if you have your confidentiality agreements, you can return them to Sue Ann or myself.
You did, that's all.
It is a confidential discussion unless a court orders it open. That's why we have the recording. That's why we have the basis, and we'll move forward.
I move we adjourn the closed session and go back into open session.
We have
Sorry,
a
second.
Motion by Commissioner Lett, seconded by Commissioner Witches to conclude the closed session.
Before the vote, Madam Chair, I just want to indicate to everyone joining remotely what this means after the vote to adjourn. If it passes, you will leave this Zoom meeting and rejoin the Zoom webinar. So the meeting that we were on right before this, you can use the same link and you'll be able to join that one again. Thank you.
All right, all in favor of adjourning the closed session, raise your hand and say aye. Aye. All opposed, raise your hand and say nay. I can't see them. Aaron and Rhonda, could you verbally indicate your vote?
Aye.
Ooh, that was two.
Aye.
ayes. All right, the ayes prevail. It's unanimous. The closed session is adjourned. All right, so at 5:19.